Namaste, welcome to the new session on MOOC, that is Right to Freedom of Speech and Expression and its reasonable restrictions under the Constitution of India. So this is a very relevant topic, and we'll be covering today what is right to freedom of speech and expression, then what are the relevant provisions in this regard laid down in the Constitution of India, what are the reasonable restrictions in these, and what are the various observations made by Supreme Court of India and various high courts, and ultimately we will reach to a conclusion where we will see what we can do to achieve this right and what we should not do in regards to this right in order to secure a great nation. So first thing comes first, I will start with a famous quotation given by the former President of India, Dr. APJ Abdul Kalam. Dr. Kalam once said that freedom of speech and expression is cornerstone of any particular democracy. India being a democratic nation, if the right to freedom of speech and expression is not secured, then all other rights given by the Constitution or any other law will be jeopardized. So it is the mother of all other rights, all other liberties, and it should be secured for every aspect and for every citizen. If citizens of India do not get this right, then there will be some confusion, there will be some revolution, or there will be some debates as to the necessity of other rights also. So as we know that this right is a fundamental human right which is very much important for human existence, then it is not only secured by the Constitution of India, but it is secured by many international covenants, treaties and agreements also. So in India, what is this right? If you talk about this right, then we find that this freedom of speech and expression is a right which is secured by the Constitution of India or other laws. But this right means that one can use his opinion, can disseminate his opinion, views, perspectives without any fear or retribution or any sort of censorship. If there is any censorship or retribution or any sort of pressure, then this right will not come into play. So going forward, we should say when this right was actually originated. So whenever we talk about the origin of this right, we find that this right was actually created with the existence of a human being itself. But still, as far as we refer to written scriptures, we find that in ancient Greece, there was one particular term known as parrhesia. Parrhesia means using one's will without any fear or censorship. Then we come to 17th and 18th century, when Enlightenment period was there. Many revolutions were taken place for Enlightenment, and John Locke and others were the forerunners in this regard. They raised their voice to secure this freedom of speech and expression. Then if we talk about the fundamental rights concept and the right of speech and expression, then we know that the American Constitution is the oldest constitution in the world, and American Constitution, through its first amendment, brought the concept of freedom of speech and expression for the first time in the world in any form of written constitution. After that, many constitution follows the same, and India also follows the same after it became independent in the year 1947. Now, when we talk about fundamental rights of freedom of speech and expression, then we should refer to the Constitution of India. What does the Constitution of India provides? So as we know that there are 6 fundamental rights in the Constitution of India. Among them, right to freedom is a very important right which is provided under the provisions of Article 19 to 22, and Article 19 specifically provides 6 fundamental freedoms, and among these 6 fundamental freedoms, under Article 19, Clause 1, Subclause A, right to freedom of speech and expression is guaranteed. Now, This provision says that all citizens shall have the right to freedom of speech and expression. Now, it point to be noted is that all citizens, not all people residing in India. So, all citizens will have the right to use this freedom of speech and expression, not any alien citizen or something like that. So, we can say that citizens can have the right, but again there is another article, that is Article 19 Clause 2, that provides for 8 restrictions that can be imposed by the state to our freedom of speech and expression. That means for freedom of speech and expression is not an absolute one. We can use this right, but to a limited extent. If there is any sort of violation of any reasonable restrictions provided in Article 19 Clause 2, then the state can snatch this right from us. Now, it will be very important to know what are these reasonable rights, and of course after that we will go through some famous Supreme Court and High Court's judgments by which we can know the scopes and extent of this right. So, as we know that Article 19 Clause 2 of the Constitution of India talks about reasonable restrictions to be imposed by the state on the right to freedom of speech and expression. So there are 8 reasonable restrictions that can be used. The first among them is security and integrity of the nation. Now, what is that security and integrity? Security and integrity means the defense of India in regards to its economy, its regards to its territory, its regards to its people. So whenever one person seeks to do anything in the name of freedom of speech and expression which jeopardizes the national security or the sovereignty. Sovereignty again means what? That no other nation can interfere in our internal matters. If we are doing something by which other nations are getting the opportunity to interfere in our internal matters, then this right cannot be used, and the state is actually eligible to snatch this right. Then the next one will be friendly relations with foreign countries. So, as we know that the world is a global village, and there we interact with other nation. We cannot stand alone. So we cannot stay alone also. So this is very important to maintain good relation with other nations also. So if we do anything by which our relation with any other foreign state becomes bad, then we should abstain from doing the same. Otherwise, right to freedom of speech and expression will not work in this regard. Then another right is, of course, public order. Now, what is public order? In public order, we know that the state is responsible to maintain law and order in the society. Law and order means to protect ourselves from being committed or being subjected to any crime. And if any crime takes place against us, then the state is responsible to protect us. But the thing is that when it becomes an issue of public, that means when crime is committed not only a single person but against many persons, against the society, then it becomes an issue of public order. And if anyone does anything by which he is creating noise, he is creating nuisance, he is creating any other hazard to the public, then his right will be curtailed or can be curtailed. Then another is decency or morality. So decency is, of course, a standard of living. Actually, in our society, from ancient India also, what we see that we live in a country where we follow some moral standards. So these moral standards should be followed, and if anyone contravenes these moral standards in the name of freedom of speech and expression, then again this right can be curtailed. Then another restriction will be contempt of court. So contempt of court is defined under Contempt of Court Act 1971. It basically means lowering down the image or public perspective of a court of law. So if anyone does anything by which he tries to lowers down the image of the court, then he can be restricted to do so in the name of reasonable restriction. And of course he can again be punished under Contempt of Court Act. There are two types of contempt of court: civil contempt and criminal contempt also. Then another is incitement to an offence. Now what is that incitement to an offence? If any person instigates another person's or incites another person to commit an offense, then he cannot take the plea that yes, I have the right of freedom of speech and expression, and by exercising that right, I am going to incite him to commit an offense. I am not committing the crime, but I am inciting him to commit the crime. In the name of freedom of expression, he cannot do the same also. Then another is defamation. So defamation has three ingredients. Defamation means lowering down the image of some person in the eyes of third person. That means there is a statement which is defamatory, which is published, and the statement relates to a particular person. So if these ingredients are fulfilled, then defamation can take place, which is also a criminal offense under section 499 of Indian Penal Code, and which is also civil wrong under tort law in India. But the thing is that in the name of freedom of speech and expression, one cannot defame another, because it's an offense, and committing an offense, it can be never an excuse in the name of any sort of particular right. As we know that this right is totally not absolute. This right is subject to several restrictions also. Then when we proceed, then we find that this right to freedom of speech and expression has several connotations also. Say for example, it is not only used by verbal mechanisms. Say for example, it is not only oral, or we can say it can also be written, but verbal and written are not only way of expressing one's freedom of speech and expression. Sometimes it may be expressed by way of gestures, postures. You can see that in matters of LGBTQ community, earlier it was a crime under section 377 of Indian Penal Code, same-sex relation. But the question when came up before the Supreme Court, then Supreme Court decided no, it is also a right to express. Some person wants to express himself or herself in certain way, he can use, and that is done in a private room. So it cannot be indecent behavior, or it is not actually against the morality also. So they permitted the same, and they made this section 377 unconstitutional also. So going forward, when we talk about freedom of speech and expression, then we find that reasonable restrictions should be used with proper care. If reasonable restrictions are not used to proper care, then again right to equality will be violated. We know that we have right to equality under Article 14 to 18 of the Constitution of India, and Article 14 also talks about reasonable classification. So when a state wants to impose any reasonable restriction on the freedom of speech and expression, then what will happen? The state should adhere with the minimum norms laid down by various Supreme Court of India judgments. Say for example, Maneka Gandhi versus Union of India. Say for example, E.D. Royappa versus State of Tamil Nadu. So in these cases, what happened? The Supreme Court said that okay, state is empowered to make any law, use any restriction, but this should be justified, this should be reasonable, and this should pass the test of reasonable restrictions. Reasonable classification. Now, when we talk about the scope of this fundamental freedom of speech and expression, then we find that Article 19, Clause 1 only says all citizens shall have the right to freedom of speech and expression. But it does not say what will be the scope, what will be the area of application. So whenever there is any confusion in this regard, then we always must refer to Supreme Court of India judgments, because it is the constitutional court, it is the apex court in India. We can also refer to high courts, but there will be some limitation, because high court judgments is applicable to the jurisdiction of that particular high court only. But when we talk about Supreme Courts of India judgment, then it is applicable to whole of India. So we should refer to Supreme Court of India judgments by which the right has been extended, the right has been applied, and in some cases right has been curtailed also. So, first of all, in 1950, there was one case, Ramesh Thapar versus State of Madras. It was a very famous case. For the first time, Supreme Court of India said that yes, right to freedom of speech and expression is a fundamental right, and state should take all endeavors to protect the same. If state is failing in the same, then what will happen? It will not be actually fulfilling the mandate of the Constitution of India. Then another case is Sakal Papers versus Union of India. It's case of 1962. It talks about the right to freedom of speech and expression of press, media. We know that press, media plays a very vital role in the growth of any nation, and it is also known as the fourth pillar of democratic society. But the thing is that whether the press has also the right of freedom of speech expression, because it's not a natural person, it's an artificial person, so whether it has any right. So in Sakal Papers case, the Supreme Court said yet it has right. But before that also, there was another case in 1950 itself, and that is Brij Bhushan versus a State of Delhi, in which the Supreme Court directly said that yes, freedom of press is included under the four corner of freedom of speech and expression. Then another case is Indian Express newspapers versus Union of India. In that case, it was held that this freedom is not absolute one. It can be curtailed in many cases, as mentioned in Article 19.2. So if one wants to use this freedom, then he should take care of the fact that his freedom can be restricted, and in some point of time he can be punished also for violating any particular law. Then another famous case in this regard will be Shreya Shingal versus Union of India. In Information Technology Act 2000, there was one provision, section 66A, which actually said that if any person publishes anything in social media platforms or any electronic gadgets, then what will happen if the authority deems it necessary to take action against him or her on the ground that it spreads vulgarity or it is not reasonable, then he can be jailed, he can be taken into custody, he can be punished. Then Supreme Court took up the matter and it said that no, this cannot be done in the name of reasonable restriction. If you want to really punish someone, then first of all define that term vulgarity, unreasonable, and these things. If these are not defined, then you cannot take a plea of this section, and this section should be made unconstitutional. Then proceeding further, we have another case, and that is a very relevant case, Common Cause versus Union of India. I was also talking about this case as it relates directly to section 377 of Indian Penal Code, where same-sex relations were granted the sanctity by the Supreme Court of India. So in this case, yes, this was the case in which a same-sex marriage or a same-sex, not marriage, actually same-sex relationships, marriage is not, same-sex marriage is still not a ground of right. Now the case is going on in the Supreme Court. Supreme Court will decide what will it do with this case. But for now, same-sex relationships are granted status. So then another case is Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal, 1955. In this case, it was a very relevant case because in this case it was said that the broadcasting agencies, the media, shall have the right to telecast live any cricket match. In this case, actually, the Cricket Association of Bengal forbidded this media broadcasting agencies to telecast the cricket match live. So they approached the Supreme Court. Supreme Court said that no, you cannot do this. The state is not eligible to do this, and state has to ensure the freedom of speech and expression of media also. Then going forward, another case is Bharatiya Janata Party versus Election Commission of India. In this case, it was held that freedom of speech and expression also includes giving speeches, lectures in public domains, for example, giving speeches by public figures, but they must bear in the mind that these are not absolute rights, and this can be restricted in the parameters given in Article 19 Clause 2 also. Then there is another case, Subramaniam Swamy versus Union of India, and that talks about right of privacy versus freedom of speech and expression. So there should be a balance. In this case, the Supreme Court said there should be a balance between right of privacy and freedom of speech and expression. If freedom of speech and expression curtails the right of privacy, then there will be a hodgepodge, and the rights cannot be sustained. So there should be a balance between these two. So going forward, there is a widespread debate in regards to the right of freedom of speech and expression and national security. One segment of people are actually saying that the state is using the reasonable restrictions unfairly in the name of Article 19 Clause 2. Another segment of people are saying that some people are using this right just as a shield, but in order to destroy the national sentiment, national fabric, and national security also. So, from the initiation of the Constitution of India, this debate has been going on. But if we see the present context, then we find that even the Supreme Court has punished many persons for violating this freedom of speech and expression, or you can say for crossing the limit laid down in Article 19 Clause 1 in the name of freedom of speech and expression. And in other cases also, Supreme Court is saying that no, state is unfair in using this reasonable restriction. If we talk about certain laws in the name of which this freedom of speech and expression can be curtailed, would be UAPA, Unlawful Activities Prevention Act 1967, then APSPA Act is there, then NSA Act 1980 is there, then other national security laws are also there, in addition to the crimes defined under Indian Penal Code. Say for example, section 124A that relates to sedition. So, if any person does anything by which the state considers that it is a threat to the national security, then of course the state can impose reasonable restrictions. But now again, the definition of national security is not defined anywhere. The definitions of unlawful activities is although defined, but there is a great scope of misuse on the part of the state also. So the state and the theme of speech and expression as laid down in the Constitution of India must be balanced. Otherwise, what will happen? Otherwise, there will be a problem. We can see in JNU, we can see in other institutions where people are saying Bharat tere tukde honge. Whether it is justified, I leave up to you that you consider whether it is justified or not. If it is not justified, why the Supreme Court or other competent courts are not taking initiative? If these are justified, why states are actually writing charge sheets in these cases? So these are matters of public concern, but there is no hard and fast rule to identify these issues. But as we know that this freedom of speech and expression has both verbal and non-verbal communications. That means it can be spoken, it can be written also. Now, in terms of written connotations, it includes paintings, it includes caricatures, it includes other form of writing also. Again, it also extends to music and other artistic works also. But we should remember that in no case this can violate the provisions of Article 19 Clause 2 that provides reasonable restriction. Now, for example, caricature, painting cannot be made in such a way that depict the wrong image of some person, or wrong image of certain deity, or wrong image of some personality. If it contains wrong image, then it will be punished not only under any particular law, for example Indian Penal Code, but if it also relates to any person's integrity, if it relates to woman, if it relates to any particular deity, if it relates to any national leader, if it relates to any person whatsoever nature, then he right of freedom of speech and expression will be curtailed to that extent. So artistic work is okay. We can use our artistic works. We can use our paintings. We can use our music. We can use advertisements. We can use pamphlets, leaflets. But we should keep in mind that this should not in any way violate the reasonable restrictions, our sovereignty, unity, integrity, morality, decency, then defamation, incitement to an offense. These things should not be contained in that. So there will always be certain issues. Say for example, in the name of national security, internet shutdown took place in Jammu and Kashmir, and Jammu and Kashmir then reached to Supreme Court, and Supreme Court said yes, for a long time you cannot cut internet in that particular place. But then state gave internet connectivity. But what happened with the rights of those people? And if these rights are given, then if they misuse the same, then who will be blamed? So there needs to be a serious research, there needs to be a serious debate, deliberation in this regard. Otherwise, constitution says something, state wants something else, people want something else. If these things continues, then the national fabric will be harmed. So in the name of national security, no one can violate freedom of speech and expression. Again, in the name of freedom of speech and expression, no one can violate national security. I remember one quotation by Dr. B.R. Ambedkar, the founding father of this Constitution of India. He said that whenever there will be a conflict between national security and personal liberty, I will always prefer national security. And if we take this quotation in concern, then we should always go with national security. But again, in the name of national security, there should be a total destruction of right to freedom of speech and expression. So, lastly, in conclusion, what we have gone through today's MOOC lecture will be that freedom of speech and expression is a fundamental human right that is not only guaranteed under the Constitution of India, but also under other constitutions of the world, also under many international covenants, treaties, agreements. And this freedom of speech and expression is the mother of all sort of liberties, all sort of rights. Is this right is not given, then no innovation can take place, even no exchange of knowledge, idea, perspective, opinions can take place. Without that, we will be a simple animal. We know that human beings are also animals, but they are rational animals. If this right is snatched, if this right is not protected, then we will be mere animals. And we are not born to be mere animals. But again, if we use this right against any person to just satisfy our greed, or to satisfy our revenge, or to satisfy our any ulterior motive, then again it is not justified. The right to speech and expression is the cornerstone for using our electoral rights also, for saying something in public domain also, for maintaining the accountability of the state or the authorities, for you can see for other reasons also. But judiciary needs to play a very important and prominent role to maintain balance between the interest of the state and the interest of the individual persons in regards to freedom of speech and expression. And judiciary has been doing so. But again, as the time is evolving, along with the time, law is also evolving. Along with the law, the scope and the area of application of this right of freedom of speech and expression is also getting extended. Earlier, there was a time when newspaper was not there. The newspaper was published, a platform of speech and expression. Then after newspaper, this telegram was also telegram also came into existence. Then it also became one part of this freedom of speech and expression. Now social media is there. Now internet is there. Within a fraction of second, we can disseminate the information to the whole world. And you can see, if we misuse this right, then what can take place. We can create riots, we can we can do any illegal activity by spreading rumors and everything. So state should take precautions so that these rights are not misused. Again, states should ensure that those who are in need of using freedom of speech and expression for any ulterior motive or whatsoever, they should not be prohibited. Then again, another aspect is that ultimately the nation should stand in the Global Committee of Nations, and if we want to stand in the Global Committee of Nations successfully and we want to be superpower, then we need to use this right. We cannot curtail this right, but balance is the main thing. And of course, certain laws that are unreasonable, that should be limited. Of course, state, by the term state, I do not mean only the central government. Here state means the central government, the state government, the municipalities, the parliament, the state legislatures, together with the civil societies, for example NGOs and others, we can create one aware society where these rights will be used for good purpose, for uplifting the state to next level, and for overall national prosperity. So thank you so much. Jai Hind.